Hey, this is Dr. Hart, and today I'm talking about the main body of the Constitution, Articles 1 through 7. So, Article 1 describes the legislative branch, Article 2 the executive branch, and Article 3 the judicial branch. So, these three articles express the idea of separation of powers into three distinct branches of government. The number of words declines between these three articles. Article 1 is the longest because the founders wanted Congress to be the most powerful branch. So obviously most powers that were given to government were given to the legislative branch. Then Article 2 is the second longest, and it spells out who will be the head of the executive branch. That, of course, is President of the United States. And Article 3 is about the judicial branch, which establishes one Supreme Court, sets out its jurisdiction, and states that other courts, as it calls them, inferior courts, can be established by Congress. So the first three articles are sectioned. The first one, being the longest, has the largest number of sections, 10. Then we have 4 sections in Article 2, and we have 3 sections in Article 3. Then we go on to Article 4. It has 4 sections, and it describes the essence, or much of the essence, of federalism. Relations between states and relations between the national and state governments can be found to a significant extent in Article 4. And then, of course, also we will see later in Article 6 as well. So Article 4 protects states, jurisdictions, and territories from being changed without their consent by the national government. And it also sets out how states relate to each other in terms of the validity of laws and judicial acts. So a judicial act in one state is supposed to be recognized as valid in another state. Also, it would seem that from the reading of Article 4 that a law passed in one state should be recognized as valid in another state, but it never has been to a full extent, particularly on the issue of marriage, just family law in general, marriage and divorce. And this was the case not just with same-sex marriage, but with traditional opposite-sex marriage as well. There have been cases when a divorce in one state would not be recognized as valid in another state. So the thing to take away from this is that while judicial acts of one state have traditionally been recognized in other states, recognition of laws of one state have not always extended to other states. It also talks about things like states have to return fugitives from justice to the state where those fugitives are being sought for crimes they committed in those states. But states do not have to enforce each other's criminal laws. For example, if in Hawaii and Utah gambling is a crime, this doesn't oblige Nevada to treat gambling as a crime. Article 5 talks about amendments. There are 2 ways to create constitutional amendments. Only one has ever been used. This is when 2/3 of both chambers of Congress pass an amendment, and then 3/4 of the states ratify it. The states have 2 ways in which to ratify. One way is by direct vote by the majority of state legislatures, and one is by calling special conventions specifically for the purpose of ratification. In 26 out of 27 amendments, the states have ratified directly by the vote of their respective state legislatures, and only once, in case of the repeal of prohibition, was the amendment ratified by special conventions. The second way to change the Constitution by adding an amendment is for 2/3 of the states to call for a constitutional convention and then have the convention write the amendments and pass those amendments, and then send those amendments for ratification by the states. And in that case, 3/4 of the states would have to ratify. This way has never been used. We never had a constitutional convention after the original one that created this constitution. There have been a number of people who called for constitutional convention for years, if not for decades. Mark Levin comes to mind, but there have been others as well. Probably the main reason why we never had a constitutional convention after the original one is due to fear that a convention called for the purpose of creating amendments won't do that, and instead would throw out the Constitution and substitute a whole new document in its stead, because after all, that's exactly what happened with the Articles of Confederation in 1787. The delegates were sent there to amend the Articles of Confederation. They ended up throwing out the articles and creating a whole new document. Now, Article 6 talks about three things: debts, supremacy, and oaths. Debts states that the debts incurred during the Revolutionary War will continue to be valid. The supremacy clause is highly important, and it goes to the essence of relations between the national government and the states. It says that when a state law and a national law conflict, the national law trumps the state law, and the state law is null and void. And oaths has two parts to it. One part says that legislators, both national and state, are to be bound by an oath to support the Constitution of the United States. And the second part says that no religious no religious oath is to be administered for any position in government of the United States. Lastly, we have Article 7. Article 7's significance is limited to the time of ratification. It stipulates that 9 states need to ratify in order for the Constitution to be adopted. This was a break with what the Articles of Confederation contained, because Articles of Confederation, if you recall, required unanimous consent. And so this is the body of the Constitution. Next lecture will be about amendments. So thank you, and I will see you in the next one.